Hi, I'm Brad Hunter, a Regina family law lawyer, and I'm speaking today with Charmaine Panko, a Saskatchewan family law and collaborative lawyer, as I am, about something that we're working on called the Concierge Collaborative Process. So, Charmaine, why don't you tell us about the Concierge Collaborative Process?
Absolutely. I am so excited about working with Brad on this because, everybody who goes through a separation and divorce process really needs to have their own separate, independent legal advice. And in working through a process where you know that the two lawyers that are involved are actually like-minded in wanting to help you get to a resolution that's timely, that's cost-effective, and that really meets your needs, is the essence of collaborative process. And we are designing an opportunity for it to be a concierge process, which means that we're going to customize it in a way that you won't find anywhere else.
And although this will work with couples who maybe aren't that far apart to begin with, it can also work in situations where there's a lot of conflict over information or maybe over other issues, or there's some disagreement or there's some uncertainty. On my experience, even those types of cases where people are at odds at the start, they're likely to settle anyway, and they often get options, and there are ways to develop ways that they can come to a solution they both can live with and get on with their lives. Let's just talk about timing to start with. So what kind of timing are we looking at doing this?
We are going to try to help pace your progress over the course of a 3 to 6 month period. And what we are expecting to occur during that time period will depend in large part about what it is that the decisions are that you need to make. But we're going to actually work together to set out the timelines and the expectations.
I think when we onboard people, what part of it's going to be is very early on, we're going to say often the thing that drags out a divorce is just getting the basic information. It's not controversial, but I think one of the starting points will be, if you want to get your divorce done quickly, we will assist you in getting all of the information you need as soon as possible, and that facilitates us doing the negotiation. But that also raises an expectation that we have to put a priority on getting it done. So kind of from day one, the meeting dates will be set. The documents, most of them anyway, will be identified. Often, if things like valuing a house or valuing something like that needs to be done, we can identify that quickly as well. And so we keep going quick. Why is it so important to deal with these things in a timely way?
Well, you mentioned, Brad, about setting meeting dates as part of the planning. And I mean, I think that one of the things that really back people up is the lawyers, that you're trying to coordinate busy schedules, and the sense of moving quickly is actually, I mean, it's relative, right? We're not saying, oh, you're going to be divorced in a week. I mean, a separation divorce, it takes a year because you're not eligible for a divorce for a year, but it's about getting some momentum right from the beginning. And if, have you worked with lawyers in the past sometimes, Brad, where you feel like all you're just doing is trying to find meeting dates?
And, I'm limiting myself to doing mediation collaborative practice, so I have control over my schedule. When your lawyer is going to court, they naturally put the priority on the cases that are going to court. I think that's what I did, and that's what's expected. So we're able to kind of do it within our schedules and know what's needed and get things done. Let's talk about a fee structure. One of the questions is often, how much is this going to cost me? And generally, lawyers ask for a retainer of a set amount, but that's only where it starts. It doesn't end there. What are we going to do about fees?
Another thing that I'm super excited about is the fact that we're going to assess your case, and we're going to set a price. We're going to say, this is what this is going to cost you for this time period. And that way you don't have to worry about what those fees are that are adding up, because we've already assessed that for you, and we're going to work within those parameters.
Now, let's just talk about one question. Is you and I have worked together in the past, but we're not going to be representing the people together. I'm going to represent one of the parties, you represent another. So how do we maintain the ability to look after my client's interests not that we're going to be compromising, that we're going to do an effective job of dealing with my client. You're going to do an effective job of dealing with your client if there are those tough discussions.
Mhm. Well, it's about building relationships. So, Brad and I have a relationship, a professional working relationship with that over the course of time, the work that we've done together, we can trust each other. And we want to make sure that you, as our individual clients, feel that you can trust us as well. So we're going to want to spend some one-on-one time with you in addition to the joint meetings. And
I think part of it, Charmaine, too, is in most law cases, there's literally 100 things that need to be decided. A lot of those decisions, people have pretty much a good understanding at the beginning. Some of them, they don't have the information, so they can't make a decision. And there are a few points, but you can usually find those out early where there is some conflict, often around what you're going to do with the children or if there's been an inheritance. But once those are identified, we can spend the time talking about those issues to see if there are ways to settle them, rather than spending a lot of time on all those other issues. So generally, when people are going through a divorce, they agree to about 95 or 98% of things, and there are some sticking issues, whether it's support levels, whether it's activities for the kids or parenting times. But if you get those screened to the points that we can get to those discussions quickly, which in my experience is they kind of don't get resolved very quickly any other way.
Well, and let me ask you this question, Brad. Those are there, are we going to disagree about the law and how the law applies to those?
From time to time. My experience has been is once you have the facts, and facts are generally things like values. Around kids, it's a different concept that often the questions answer themselves. But sure, there's going to be disagreements on how a matter should be dealt with. My experience is often there's no idea we often talk in references to what a judge might do, even though case will never be seen by a judge. And sometimes it's very clear and sometimes it's very unclear. Often too, those disputes that people are fighting over, when you put them in the context of the whole situation, often aren't that big. And if you put them in that context, they're much easier to resolve or compromise over.
Yeah, and sometimes, we need to talk about our differing opinions, and we want to talk about that with you as the client all together, so that, it's almost, it could be a flip of a coin. One time I might represent the spouse that would be entitled to spousal support, and Brad might be representing the person who would be obligated to pay. But then the next week we could have exactly the opposite. And so we're going to both understand the law the same way, but how it gets applied is going to be different based on the facts. And so we want to talk to you about that, which helps you understand the how the law fits in your situation, that it's not of the highest and only measuring stick, because it's one of them. And the way in which you will apply the law to your situation is what we're going to want to help you use as option generating. But what about the case, Brad, where honestly, they just can't make a decision on something? What are we going to do about those?
Well, I mean, if you get to the end, so our process will be a fixed fee for a fixed amount of time and working. At the end of it, if we believe it's time to continue the negotiations, it's either complicated or we need to work on it some more, we'll work out a new arrangement. But one of the options that people will have will be mediation, arbitration, which is a blended process. I'm both a mediator and an arbitrator. I won't do it because I'm representing one of the parties, but that someone else comes in, maybe a fresh set of eyes. We've limited the issues, so we've settled 98%, and there's 2% to settle, or 3 or 4 issues, let's call it that. 2 issues or 1 issue to settle. We'll be in a position to have one person come forward, hopefully resolve it. But if they don't resolve it, then they can switch it to an arbitration. And what that arbitration would be is that third party would decide what's happening. There's a number of senior lawyers or retired judges who are very experienced and competent. And the advantage of that over going to a trial is it's going to be very focused. The evidence will be focused. And often there's not a dispute on the facts. There's no dispute on the evidence. Instead, it's what it means.
Exactly.
And that when you go to court, you'll spend most of your money calling witnesses, etc. and we can get it down to where either the facts are agreed or there's a narrow part that people can't, that people can testify on. So the idea would be to have a system where you start in a collaborative process, you see how far you can get. As I say, the vast majority of people will settle. And those that don't can say, okay, we know what we're up against. Let's take it to the next level. The next level is very focused. And depending what it is, you may even represent yourself if it's over an issue that is more about, let's say, your dog or something. And I literally have had cases about dogs. You don't need your lawyer. You need to explain it to somebody directly. So that is an option, which I hope people will do. You end up having a system, but that way that you can get on with your life with a clear path within a defined period of time, as opposed to entering a system which has no date end. Another thing, though, that I think is extremely important to people is privacy.
Huge.
And court decisions are public. Ones over children, they will try to anonymize those, although often you can guess who they're talking about. But if you're having a dispute over your money or support, all of that information will be available online for your friends and even children to read. So that will be out there, and that is something to consider. And another thing to consider is certain people who are involved in let's say business or professionals have limited amount of time, and you, if you're dealing with a court system, build your time around your lawyer's availability and the court's availability. We're going to try to reverse that we find times that work for you, that you can plan ahead on and work around a busy schedule. So you're all able to kind of get on with your lives and lead your life as effectively as you can while you're going through the final stages of litigation.
Exciting.
It's going to be an interesting project. Again, we're independent lawyers, so we are going to be working for each client individually. And at the same time, though, with a common approach, should be able to move you through the process of your separation in an effective manner and give you the options you need. So you and your spouse make those decisions and can get on with your life with some dignity and respect for one another and with your head. Is that fair, Charmaine?
Absolutely. Just in a streamlined fashion that does not compromise the quality of your outcome.
Thanks, Charmaine, today, and we'll be working with you. We hope. Feel free to call either one of us, email you, either one of us, click on the link below, and we'll give you some further information and send you a few things. Thanks a lot.